Welcome to the latest edition of Trinity Talks. I'm Ali Crummy Lawson, a Senior Associate at Trinity's London office. In today's seminar, we'll be diving into the world of construction, and London-based partner Luke Muchmore and London-based counsel Harvinder Deol will be talking to you about challenging construction clauses, liability caps, and equivalent project relief. As a reminder, and we hope a lot of you are already aware of the format of the session, we will be having a 30-minute presentation followed by a short Q&A session. So please feel free to ask any questions that you have through the Q&A function. On that note, I'll pass you straight over to Harvinder.
Thank you, Canby. Next slide, please. Just by way of introduction, this seminar is going to be staged in two parts. The first part, which I'll be taking you through, is in relation to caps on liability in construction contracts, and we'll be covering several areas here. We'll be doing a little bit of background, high-level background, but then we'll be focusing on issues such as how the cap is calculated, and aligned with that, how the cap varies in different markets. Then we will be talking more specifically about situations where we exceed the cap, and again, associated topic will be carve-outs from the cap, which are and the common issues that are featured on many construction deals. And in the second part, we'll be talking about equivalent project relief, or EPR as it's referred to, and the background in terms of what it is and why it's used, again linked with where did it come from, and then linked with the more substantive issues and concerns that arise when EPR is or isn't used. Next slide, come in. In terms of background, the common law is often noted for the complicated issues that it raises in relation to liquidated damages, limitations on liability, and consequential losses. In common law jurisdictions, and indeed in many civil law jurisdictions, the parties have relative freedom of contract in terms of setting caps and limits on liabilities, where both parties are commercial entities. They've got the benefit of independent legal advice and are of approximately equal bargaining power. With that in mind, the caps on liability on a contractor's liability still remain typically some of the most intensely negotiated provisions in any construction contract, whilst at the same time the carve-outs or exceptions to the overall cap on liability are arguably just as important a part of the overall package as the value of the cap itself. I think it's fair to say that reaching agreement on the caps and the associated carve-outs is likely to help all stakeholders in the transaction reach agreement on the general liability regime. A balanced liability regime remains important insofar as, to the extent it's unbalanced, it can either result in excessive construction risks being taken by a particular party and or a contract price emerging which doesn't really represent value for money. A regime which is obviously correctly balanced protects all those interests. I think at this point it's probably worth mentioning that we're focusing today mainly on the financial cap on liability and the manner in which it operates. However, we probably should note at this point that parties may want to also exclude certain types of loss altogether, rather than just include them in the financial cap. Such losses often include loss of anticipated profit, revenue, opportunity, and are often termed as what we more commonly refer to as indirect or consequential losses. These can also be hotly contested, as many businesses will want to ensure they exclude their liability for indirect losses. This is obviously quite a broad topic in itself, and it merits a separate discussion, and hence we won't be covering this in detail today, but we will make this a subject of a separate webinar at a future date. So in terms of calculating the cap, although market practice is the most common driving factor for setting the level of the cap, if we look closer, there are often specific features of a deal which need to be taken into account when setting the cap under a construction contract. In terms of market variations, there are obviously variations in different sectors in terms of how the cap is set. Taken by way of example, the context of a project financed EPC contract, market practice has developed such that contractors are often required to cap their liability under the contract to 100% of the contract price. This is mitigated somewhat by key liabilities such as liquidated damages being subject to a subcap, and hence it's deducted from the overall 100% cap on liability. But part of the rationale for the 100% cap lays in the risk and return principle, insofar as the contractor is paid a premium in the project finance EPC contract for providing a fully wrapped construction risk profile, and therefore should be required to put at stake, in respect of exposure to liabilities, the total amount he was otherwise going to receive on the deal, and hence the rationale for the 100% figure. In other deals where the contractor is not providing a fully wrapped risk profile and or is paid significantly less than the total liabilities that could result from a breach of the contract, the lower figures can and often are negotiated. Other factors to be considered as well in establishing the level of the cap. There are some key questions to be answered, and some of those include the following, such as the likely amounts that are actually recoverable in the worst case scenario. So taking by way of example, is 100% of the contract price actually recoverable if a rejection scenario occurs, as contemplated by FIDIC? And this is something we'll come back to later in this talk. Other factors to be considered is the contractor's financial strength. Although we know 100% cap can be included, does it provide much comfort in terms of it being within the contractor's resources to be able to actually meet that level of liability? Because obviously it can be quite a significant figure. The next factor that's key in the discussion is the various heads of loss and damage which are expressly carved out of the cap, and this is something we'll be returning to later. And in terms of the final, I guess the overarching point is what premium will the contractor charge for agreeing the cap on liability, whether that be 100% or a lower figure. In terms of exceeding the cap, we mentioned this in the previous slide. In project finance deals, the 100% cap figure is reflective of a general requirement by project finance lenders that in a worst case scenario, namely rejection, up to 100% of the contract price should be recoverable, and as we'll see, in some cases even more should such a scenario arise. Just by way of a reminder, for those who may not be familiar with the rejection scenario, it's one where it assumes the EPC is based on something like the FIDIC Silver Book, and it deals with a situation where the contractor has failed to reach the minimum performance or construction requirements by a long stop date. In that scenario, the developer and lenders are left with basically an unusable stranded asset. Therefore, given the serious implications of a default like this, the position has developed, particularly in project finance deals, that in addition to the contractor repaying the contract price, as the developer at that point has essentially no asset to show for the sums it's paid, its liability also extends to paying breakage costs under the financing agreements. And this formula can result in the contractor assuming a level of liability which can exceed 100% of the contract price. Although this mechanic, the rejection mechanic, is commonplace in project finance transactions and in other deals, it can still cause concern amongst contractors, particularly those that are not used to working on project finance deals or maybe new to the FIDIC form of contract, given that the potential uncapped liability can lead to for the contractor. One of the rationales for adopting this approach of exceeding the cap reflects the extent to which lenders are assuming construction risk, and this is often a must-have for some lenders. However, it's also not uncommon to see the additional exposure to financing costs also being capped, so as to result in the overall liability not being completely uncapped, but being a certain percentage over the 100%, if that would be the cap that was included on the general limitation of liability. We touched upon the issue of exceeding the cap on liability, or perhaps more accurately, having a carve out on the cap on liability to cover cost and rejection scenario. However, it's important to remember that carve-outs from the cap on liability are not unique to rejection scenarios. Market practice has developed in a number of sectors to require contractors to accept additional carve-outs to their overall cap on liability, with the effect being that a handful of other situations exist which require the contractor to potentially accept uncapped liability. We can examine some of these in a little bit more detail in the next slide. So, examining some of these other carve-outs that we just referred to, liabilities to third parties is a very common one. Employers and their projects are always exposed to potential liabilities to third parties, even where those liabilities are actually, in fact, caused by the contractor. Some of these liabilities include, for example, liability for death, injury, or property damage to third parties arising in connection with the work itself. It can also include statutory fines and penalties, for example, environmental or health and safety related offences. These employer liabilities are usually covered off by way of back-to-back indemnities from the contractor. However, the fact that in most cases the employer has little or no ability to control its level of exposure to third-party claims and/or injured third parties are equally entitled, at least at common law, to seek to recover their losses from the contractor, in addition to or even in substitution of the employer, means it's difficult to consider capping a contractor's exposure. To put it another way, the third party is not obliged to limit its claim to the extent of any cap that exists under an employer-contractor contract. Therefore, it's sort of inequitable for such liability to be capped where a third party chooses to pursue its claims with the employer, but leaving it uncapped if the third party chooses to claim directly against the contractor. To the extent that liabilities to third parties are of a purely contractual nature, for example, delayed damages to a power purchaser, then this may give rise to negotiating a different position than liabilities owed to a party in general law. That said, where the contractor's cap has been adequately sized, then it's more usual for such third-party damages to fall within the overall cap, with any exceptions being negotiated separately due to deal-specific or cost-specific reasons. In terms of the cost of carrying out the works, contractors are typically obliged to carry out any rework or to rectify defective workmanship or design prior to the completion or taking over of the facility. This carve-out seeks to prevent any potential arguments that any pre-completion rework is a liability as such, which accounts towards the overall liability cap. So essentially, any cost overruns that the contractor hasn't foreseen that otherwise shouldn't have been covered can't be, to the extent that it's actually being expended by the contractor, that can't be counted as a liability, and hence the cap is not reduced. Recover under insurances, this is quite a common one. For example, under construction or erection or risks insurance, such policies generally recover reinstatement costs subject to an excess or a deductible in the event of loss or damage to the works during construction. Such insurance is normally taken out for the benefit of all parties rather than to specifically cover any particular party or any specific liabilities. But to the extent insurance monies are available to the contractor, or they would have been had it not been practiced for a contractor's failure to insure or any vitiation, then carving out insurance recoveries means that the contractor's obligation to reinstate, which is otherwise subject to the cap, does not count as a liability and hence does not account towards or erode the overall cap. This sort of makes sense if we look at it from the perspective that the insurance monies paid or payable are not in fact a liability on the part of the contractor, and technically the contractor has suffered no loss. The insurance proceeds do not represent any loss or pain, so to speak, from the contractor side, as the liability has been satisfied by the insurer. To this extent, market practice has developed such that the contractor's cap is not reduced by the result of any liability being paid by a third-party insurer. The last one on the slide there is project intellectual property infringement. So the consequences of a project infringing some third party's IP can include damages, additional licensing fee, or even the costs of procuring alternative non-infringing goods, and even in the worst case scenario, the cost of having to redesign the project as a result of an IP infringement. I guess that's more of an issue where the technology that's being employed is novel, and the technology or the design is more novel, and to the extent it is sort of more novel or innovative, then there's a greater potential impact of the project of an infringement claim, and therefore it's common to see liability for third-party IP infringement carved out of any overall cap as a result. Again, probably falling into the same category as third-party liabilities. In sectors where there's lots of emerging technology, separate and higher capping arrangements are sometimes applied specifically to IP-related liabilities. Fraud, corrupts acts, willful breach and misconduct. In most jurisdictions, it's not possible to limit liability for fraud, and in some jurisdictions, it's not possible to exclude liability for gross negligence or similar terms either. Nonetheless, they're relatively common express carve-outs, which of course add nothing if they cannot be limited as a matter of law in any event. But despite occasional conceptual arguments about the potential distinction between willful breach and willful misconduct, it's rare for contractors to object to these carve-outs, although there may be a requirement for the willful act to be directed from a senior level of management, but that's obviously it depends on contractor to contractor. Liquidated damages we touched on before. The higher the overall cap, the more likely it will be acceptable for LD liability, which itself is usually sub-cap, to sit within the overall cap. Conversely, the lower the overall cap, the greater the potential need to carve LDs out in order to ensure the cap is available to cover downside scenarios. In contracts involving project finance, the trend tends to be for such liquidated damages subcaps to fall within the overall cap. A situation where the LD cap falls perhaps outside of the overall cap, then the price for the contract will become a factor in the discussions, as we mentioned before. In terms of enforcement costs, caps are not typically designed to cover the potentially significant costs of employers having to enforce their contractual remedies to pursue claims on behalf of the contractor under other project agreements. In this sense, employers often seek such enforcement costs being carved out of the overall cap. However, it's important to note that where a high cap has already been agreed, such as 100% or near 100%, then contractors often push back on this requirement on the grounds of the cap already being sufficient. Again, this is one that needs to be decided on a case-by-case basis, taking into account the size of the cap already provided. As we touched on before, the majority of the carve-outs discussed above are also candidates for carving out an exclusion or waiver of expected inconsequential and direct loss, but that's, as we mentioned, something that we'll pick up in a separate discussion. A quick point on drafting then, just around that one off. It's also worth noting that the concept that we've already discussed need careful drafting to ensure that all the relevant concepts that we've noted are captured. Although the concepts themselves are quite commonplace in various sectors, we at Trinity, we still see drafting that comes across our desk that fails to properly incorporate them in such a way that ensures the cap is disapplied should one of the carve-out scenario applies, or actually apply when it needs to be capping something. So we often see this is closely matched by drafting we've seen, which can inadvertently cap some of the scenarios within the overall liability when it's likely that there's not the commercial intention. This can be particularly critical in relation to liquidated damage regimes and the associated caps. So our advice in this extent would always be to check the limitation liability clauses with your legal advisors to ensure that it is covering what's meant to be within and outside of the cap is actually reflected in the language itself. At this point, I'm going to hand over to my colleague Luke Muchimore, who's going to talk about the equivalent project relief principle, equivalent project relief, and the back-to-back principle. Over to you, Luke.
Am I on? Thanks. Sorry about that, everybody. Hi, my name's Luke Muchimore. I'm a partner here in the London office, and I'm going to talk to you today about kind of clauses and terminology that you sometimes come across during negotiation of EPC contracts, and where you hear the terms back-to-back, also pass-through, and equivalent project relief. So hopefully what we present to you today will bring a little bit of clarity to you on some of those terms. I'll start then with back-to-back. The principle really there is in order to ensure that your head contract, and that might be a PPA or a concession agreement, has passed through it's a number of key obligations and liabilities into your construction and your O&M arrangements. So that's what we're doing when we talk about back-to-back or pass-through. They're really synonymous with each other. Why are we doing it? Well, really what we're doing is making sure that we minimise risk sitting with your SPV, your project company. And practically what we're talking about doing is an exercise of aligning those subcontracts, the construction, the O&M arrangements, with your head contract. So aligning it in terms of the obligations that are passed down, standards of the work and the services that need to be provided in order to satisfy your head contract, testing requirements, things like that, making sure that technical schedules are passed through and you satisfy PPA requirements for testing, certain relief events, and they're a really key part of the overall back-to-back approach. So certainly for things like force majeure and change in law, a great deal of time is spent making sure that they are passed through and back to back, and it flows through also into things like termination events and then certain rights for your off-taker or your authority to come to site, carry out certain inspections and witnessing. So the practical reality of the back-to-back exercise really then is to go through your head contract, or possibly head contracts if you've got both a PPA and a concession agreement, and really pulling out both the construction aspects of that head contract and the operational aspects, and making sure that when you're drafting your EPC and your O&M, you are flowing those things through so that the SPV is taking the risks that it's got at the head contract level and pushing them down to its subcontractors. So on the next slide, what we'll do is talk a little bit about equivalent project relief clauses, which are a particular, if you like, manifestation of that overall back-to-back principle. And what are they? Well, what they are really is an explicit clause, an explicit agreement that your contractor will have an entitlement to relief, be that to time, extensions of time, or additional costs, which is limited to that which the project company or SPV is going to be able to secure under the head contract upstream. It's a particular kind of clause, and it's got a sort of particular kind of genesis, really. Where did it come from? It certainly manifested itself very heavily in the last 15-20 years in the UK PFI and PPP market, which was an extremely mature, very competitive marketplace, where project contracts were passed through on a very, very sort of word-for-word basis, many times into construction arrangements, operation and maintenance contracts, facilities management agreements, those sorts of things. And in that domestic UK PFI marketplace, it became very much the norm. Was associated with sort of pay when paid clauses and some of the difficulties around that exist under UK law for domestic projects. So actually what you've got is a number of law firms in the UK marketplace who are almost born and raised really on the idea of the pass-through being incredibly important and sacrosanct. What we've noticed in emerging markets is really it's also manifested itself, particularly during the REAP process, the renewables IPP process in South Africa, and again in that program and over the various rounds of that program, the EPC and the O&M arrangements that we've seen coming out of that almost entirely used equivalent project relief type clauses to bind the contractors to the relief that could be achieved at the head contract level. So I think what we can take from both of those observations really is that EPR is something that is possible often when there is a competitive tension amongst the contracting community. It's something that where contractors are under pressure to offer the best terms possible, that they will be prepared and can be encouraged to take on the additional risk that EPR clauses will generate for them. But on the next slide, what we'll do is take a look at the contractor's point of view and some of those issues that it raises when it's got an EPR clause. So generally speaking, contractors don't favour EPR clauses, and I'm sure you can kind of understand why. For one, they don't have significant input into the risk allocation at the head contract level. Those have been negotiated by the SPV, by the project, with no or very little input from the contractor themselves. So the contractors, I guess understandably, see them as something of a blunt instrument to sort of be hit with, and really sometimes those are quite, for them at least, unclear or unknown project risks for the contractors. Some of the difficulties that they will obviously point out is that the risk transfer that you might get in a head contract that's been negotiated, especially in an emerging market where it's a local law governed contract, is that risk allocation is not necessarily as comprehensive as they were expecting or as detailed. So, you know, they understandably enough raise questions about where that leaves them if they are in fact having to rely on the equivalent relief at the head contract level. And the other issue that contractors often raise is that really, you know, they're in a competitive environment. They've they've pushed margins as far as they can already, so their margins are low, and they make arguments like they simply cannot, they can't be expected to take that kind of additional risk on top of just their normal rights under the EPC or the O&M, and price for the uncertainty that comes with having to accept an equivalent project relief clause. So when we go to the next slide, what we'll also do is talk about some of the other key issues when you are drafting one of these clauses. The first and key thing, especially for developers and sponsors, is that you've got to bear in mind that if you're going to use an EPR type clause, that's going to involve disclosing your head contract, your PPA or your concession to the contractor in some way, shape or form, and that might be the whole contract, that might be a redacted version of the contract, or specific extracts that relate to the reliefs that you are forcing the contractor to accept as being equivalent. And so obviously that brings with it issues around sensitivity and the potential confidential information that's in those head contracts, in those PPAs and concession agreements. And what we often see then is certain, as I said, redacted versions or extracts where things like PPA tariffs are stripped out, caps, things like that. So in actual fact, although, you know, as a sponsor, you want the benefit of the EPR clause because it does indeed pass down risk to your contractors, you're also not trying to give away the basis on which you're engaging with your off-taker under a PPA. It often means quite detailed drafting, and we've said there, it means you've got to involve your contractor in the head contract claim. There'll be an obligation to pursue that head contract claim on your SPV, questions about who bears what costs, questions of cooperation, entitlements for your contractor to attend meetings in relation to the head contract claim, and kind of what happens if there is a failure on the SPV to actually make the claim in the first place. And there's a knock-on effect to that third bullet point that we've got there in the slide, really, which is that the quality of the contractor's information and their particulars of claim will impact you as the SPV in your ability to make a claim under the head contract. So in fact, if poor information is provided about the costs that are being felt or the time impact and the delay impact of the particular event, so if we take a force majeure, if your contractor is not providing you with good information on the ground, it makes the head contract claim that more difficult, and that really needs to be borne in mind as well. So what happens then is that there is inevitably something of a tension between the almost two adversarial relationships that the SPV will have. An adversarial relationship with the contractor who's making a claim that you want to defend, but it's a claim that's equivalent to a claim up the chain that the SPV has against the off-taker, which is in itself an adversarial relationship because SPV is trying to make a claim against the off-taker or against the government or the authority for the relevant additional costs or extensions of time. So if you like, there is a sense that the SPV is stuck in the middle of those two slightly adversarial relationships, and it does make the practical management of EPR clauses really somewhat difficult. And the final point we wanted to raise there on that slide is really just to talk about how the issue of including these, and I talked earlier about them coming from a couple of sort of key sectors and geographies, but we are seeing them elsewhere. They're becoming fairly prevalent, we'd say, across solar projects in Africa. Principally because lenders and their credit committees are becoming quite wedded to precedents being set in those places. So, you know, they are turning around and insisting on them being included in EPC and O&M arrangements elsewhere as well, which leads us, I think, kind of neatly onto the question of what happens actually if there isn't an EPR type clause. Now, I think we'd start off by saying what's clear is that there is no absolute necessity for one of these. Certainly, we have banked any number of EPC and O&M contracts without an EPR clause, and there are contractors in the marketplace who are prepared to agree to it and offer it, and pricing is still acceptable from those contractors. And at that point, it's really then a question of going back to where I started at the beginning, which is that back-to-back, that pass-through exercise, making sure that both at a legal level and a technical level, that exercise makes sure that it passes down key risks from a drafting perspective, including, not just main conditions of contract, but in the technical annexes of both EPC and O&M agreements as well. All of the relevant risks that the SPV has got at the head contract level, so force majeure, change in law, delays by the particular authority or the off-taker, technical specifications I've kind of already referred to, and I mentioned testing regimes as well, and all of those together will mitigate the need for a very explicit equivalent project relief type clause. So really that sort of brings us to all of the key points I think that come out of the pass-through and the EPR type exercise. It would be nice, I think, to see then, Conmy, if anybody's raised any questions in the Q&A.
Yeah, thanks for that, Luke, and thanks, Harv. I actually got a question that's come through for Luke while you're still on. It comes saying, is a contractor entitled to its equivalent claim simply when the preconditions are the same and have been satisfied, or does the contractor have to wait for the claim to be decided at the PPA level?
Yeah, so the idea is the latter of those two. So the point of the EPR clause is that the SPV will be protected from the risk of having to pay out or grant to pay out if it's a money claim, or grant an extension of time if it's a time claim, without the requisite payment or time being granted to it under its head contract. And one might ask, and contractors do ask, why does it have to do that? If the claim is equivalent, then surely the SPV should be comfortable in taking the risk that it will make its own claim up the chain, and be compensated and relieved via time and cost. And really the answer to that is kind of the contractors can get comfortable by the detailed drafting of the EPR clause. So all of the things that I was saying earlier about being involved in the claim, making submissions that make sure that the off-taker or the authority grants the relevant cost or time. There's often references to attending meetings. Clearly, there's also just an obligation on the SPV to actually make the claim in the first place. But the contractor's comfort in that respect, and the contractor's comfort in having to wait for the decision at the PPA level, comes from the level of involvement that it is given by the detailed drafting of the EPR clause.
Great, thanks, Luke. We just got a question that's come through for you, Harv. If anybody else has any other questions, please feel free to send them through. But the question for you, Harv, is we have seen contractors wishing to pin their limits of liabilities to the correspondent limits recoverable under their insurance policies. Is this an acceptable position for the employer under a construction contract to accept?
Thanks, Conmy. Yeah, that's a very good question. We do get that one quite often. I think it's probably a case of going back to something you mentioned earlier on in the presentation, but also probably more fundamentally the philosophy of the liability cap. What's it for? And I think it's fairly well documented that the idea of the liability cap is meant to be for the contractor take the contractor itself to take exposure to liability, or whoever's giving the liability in that situation taking pain themselves, as opposed to having that the cost or whatever it is being reimbursed by a third party. So to that extent, where a contractor says, I just want to pin my liability to my insurance, then that takes us back a little bit to the point that we mentioned before about if sums are recovered from an insurer, then that's often, in at least in a lot of the contracts that we see or we advise on, that is actually carved out, because that's not a cost that's taken directly by the contractor. It obviously does differ from market to market. I mean, the rationale for some contractors, particularly maybe in something like the offshore industry, where the contracts can be high value, but the potential liability that flow from them can be even higher value. So there's the capital liability can be less than 100%, and to that extent, then pinning it to insurance would possibly not really cut into their own cap, so to speak. So to the extent you're advising employers, and we would say that would be a case of how much is the insurance for a start. Obviously, if it's anywhere near the level of liability, that may be less of an issue, but if it's significantly lower, then I think it would be a case of saying pushing the limit of liability higher. They obviously have insurance as a mitigation, but that wouldn't take away, that shouldn't take away from the fact that the liability cap is still something for them to bear, as opposed to it just being linked to the insurance amounts recoverable under insurance.
Harv, it's Luke. I'll just jump in there. I think it's worth everybody knowing that certainly that particular carve out to the overall liability cap is certainly one that we find is really heavily negotiated.
Yeah.
And one of the things that contractors often say is that they don't understand why they should be penalised themselves if they have taken out an insurance that happens to cover them for a liability that they have under the that arises under the EPC or the O&M contract. And I think in a project financing and especially in an IPP context, that's actually understandable. The contractor's own insurances behind the scenes can be distinguished from the kind of the project level insurances, and it's sometimes a landing that we reach with contractors where we say, look, the project insurances and any proceeds that you receive, Mr. Contractor, that compensate for a liability that you had to the SPV, you haven't put your hand in your pocket for those. The insurance that the project has taken out has satisfied that liability. So actually, you shouldn't then reap a perverse benefit from a cap that's been reduced when you didn't put your hand in your pocket. So sometimes the landing that's reached is that carve out is limited to proceeds or liabilities that are answered by proceeds from the project insurances, because it's the SPV that's taken those out. It's the SPV that's paid the premium for those policies.
Yeah, no, exactly. That's a very good point, Luke. And I guess that's that falls squarely within a project finance arena. I guess outside of those, it's probably more referring back to what we had. But yeah, no, I totally agree on that point about project insurances, and it'd be interesting to see if anyone has any different experience on that, actually.
Great, thanks both. I think this one is also for you, Harv, but Luke, obviously feel free to jump in if you'd like to. It says some EPC contractors are now refusing a rejection clause, even exiting bids. What is the frequency of a rejection clause? Does it remain common practice in the market? Is the situation evolving?
Thanks, Cammy. Yeah, another good one. Yeah, as I've mentioned before, the rejection scenario is often hotly contested. I mean, bringing it just for the moment to the project finance context, I think a lot of the rationale goes back to the fact that the concept itself exists in FIDIC. So I guess there's a bit of a question to be asked that if the deal itself is based on FIDIC Silverbook, should I say, which is a wrapped construction contract where the contractor is essentially taking all construction risk, then in that scenario, rejection is a feature of the underlying FIDIC book, and if that's the basis on which the deal has been procured, then I think there's much to say that concept is not not novel, and it has been there, and it's one that contractors have got used to and are aware of. But yes, that doesn't mean that it's not argued over. I think a lot of the time that some of the issues around rejection we get when we deal with contractors, and we're sitting around the table with them, is them understanding when rejection will actually occur. Because to use the term in common parlance, it sounds quite simple, and it almost could be for an unquantified reason. But we are obviously talking about, and this is what we say to contractors, we're talking about a scenario where the contractor has been unable to get the plant to reach a minimum level of performance, acceptable level of performance. So we're talking about a stranded asset scenario. So, and that is one where the lenders often they're very adverse in project finance scenarios to move away from that, because it is the sort of nuclear scenario where if that were to happen, then they're taking the worst side of construction risk, and there really isn't an asset for anyone to do anything with. So they're very loath to move away from the rejection scenario. I think somebody once described it as a scenario which is inch wide, mile deep. So the chance of the project falling into that scenario is very narrow. But the severity of what could happen if it does fall into that situation means it needs to be catered for. So I think on the whole, and Luke, obviously have your view, we still see that scenario, the rejection scenario included, and contractors being required to take that, where particularly we have PF lenders. But maybe outside of that scenario, there may be a little bit more sort of leeway to sort of discuss how that might work. I don't know if you had any views on that, Luke.
Thanks, Harv. Yeah, really just to reiterate everything you've said. So for the benefit of everybody listening, what Harv said is absolutely right. The concept of the rejection is something that the FIDIC Silver Book, and we're talking about going back to the 1999 edition, which everybody's been using for a very long time now, but it's been maintained. Often talked about substantially depriving the employer of the benefit of the works. So in two situations, both at the time you test prior to reaching, whether you call it taking over in an EPC in a FIDIC context or provisional acceptance, the asset, the power plant, whatever it may be, just can't pass its tests, and it essentially doesn't do what it's supposed to do. It doesn't do what you paid for it to do. Or and FIDIC applies it also in a defects scenario, so you could actually achieve provisional acceptance or taking over, and then in fact find that you've got a defect that, again, in FIDIC parlance, substantially deprives the employer of the benefit of the works. And I think that was the way FIDIC always sort of conceived of trying to address contractor concerns about how serious the problem needed to be for this. And I think Harvinder used it, this almost Armageddon scenario of rejecting the asset wholesale. Essentially, you are taking back your full contract price, and you're handing back your asset in its entirety. And I think the inch wide but mile deep categorization by Harvinder is exactly right. It really is a case where your EPC contract is trying to deal with a very, very rare and extremely unlikely outcome, but nonetheless conceivable, in which, and it is an outcome in which unfortunately the consequences are quite drastic if you're a contractor.
Thanks. We've only got a couple of minutes left, but just maybe two quick questions to finish off. This one is for you, Luke. Can EPR clauses work when there are multiple EPC parties?
I think there's no reason why not. In short, clearly, if you've got multiple contracts that all together make a sort of patchwork multi-contract structure for the construction of your particular asset, there is the added complication of the interfaces between those contractors and the degree to which they have caused or not caused the particular problem that your contractor is claiming for. But notwithstanding that particular, I was going to call it a wrinkle, but it's more than a wrinkle, but that particular complication, to my mind, there's no reason why you should not or could not still apply an EPR type clause to the upstream claim that the SPV will make under the PPA or the other head contract that you've got, and that your contractor's claim is dependent on that claim succeeding at the head contract level. So yeah, I see no reason why not.
Thanks. And just a last question, if you could possibly answer this in a few minutes or a few seconds, Half. How much complexity is added when the project is brownfield and not greenfield?
I think in terms of the caps that we've discussed, I wouldn't say there's I couldn't see an immediate distinction. I guess it as lawyers would say, it's case by case basis. I think maybe where there might be a greater argument there is the potential liability for third parties. If it's between a brownfield and greenfield project, depending on where it is and what the neighbouring facilities like, if the risk of damage to adjacent property owners or anything like that may be something. But otherwise, I would have thought most of the limbs we talked about in terms of caps and liabilities would apply equally to both. I guess the only caveat there will be if there's any project specifics on that deal in terms of tech or like I said, the neighbouring vicinity that may require extra enhanced protection. But I would have thought they'd probably be about the same.
I'll jump in quickly as well. I think the fact of a brownfield site tends to manifest itself, particularly in the ground risk and the approach to ground risk in an EPC contract. So what you tend to find is that the negotiation around who takes what kind of ground risk tends to be a lot more intense with a brownfield site, because contractors are reluctant to accept liability for what's been there before. So things like pre-existing contamination then becomes a far more sort of hot topic, because you're talking about brownfield, not greenfield site conditions. So yes, that can have a knock-on effect into the liability caps if we sort of take it back to what we've been talking about today. But I think the key part of your EPC that's going to be affected by that is then sort of ground risk issues and site conditions, subsurface conditions, and those sorts of things. It makes sort of geotechnical and all of those other surveys that bit more important than on a greenfield site.
Great, thank you. Well, thank you very much, Luke. Thank you very much, Harvinder, for the very insightful presentation. And thank you to everybody for attending. We will be posting this presentation with all our other Trinity talks on our website. And you can also visit our website to see the schedule of upcoming Trinity talks. Thank you, and we hope to see you again soon. Bye.
Thanks, bye.
Okay, bye-bye.